Satirist and social commentator Fran Lebowitz was interviewed on the most recent episode of Real Time with Bill Maher, and the topic turned to the United States Supreme Court. And when it did, Lebowitz sardonically, tongue-in-cheek, proposed big, bold Supreme Court reform, which visibly stunned Bill Maher. On the other hand, a Democratic senator is actually proposing substantive legislation to do just that, and we have to talk about it. But before we do, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bells before you go. All right, friends, we got a clip or two to look at here. We're going to start with this exchange between the always funny regular Bill Maher guest, Fran Lebowitz, talking about Trump's United States Supreme Court. And we're going to play this clip. And obviously, I just want to say, just to kind of preface, she is proposing perhaps reform, which is a bit too radical given the circumstances. But a Democratic senator is actually putting legislation forth, which would, not quite so radically, but still pretty radically, change and rein in this corrupt Supreme Court. So I think it's a perfect framing device for what we need to talk about. But let's start with this clip between Lebowitz and Maher.
And now the Supreme Court has ruled that he's not liable for any of this.
Right, because what he had was Supreme Court. Okay, so, you know, the Democrats had, like, elected people. The Supreme Court is completely his. You know, I mean, it's so disgraceful, this court, that it shouldn't even be allowed to be called the Supreme Court. You know, I mean, it's an insult to Motown to call it the Supreme Court. So it's not even a court. It's only a court in the sense that the court of Louis XVI was a court. You know, I mean, basically, it's a harem, okay? It's a harem. It's Trump's harem. So I always feel sorry for the three real judges on the court. You know, I know a lot of people have jobs, not me, not you, and you have to go to work every day, and there are people you don't like at work. But can you imagine having to go to work every day? Alito? You have to go to work with Alito, with Kavanaugh, you know? I mean, it must be horrible. So what Biden should do, not that you asked, but when they passed that law, the Supreme Court passed that ruling, you know, where they said, you're not the president, you're the king, which is what that ruling is. You can do whatever you want. You can never be, you know, held responsible. I thought, you know, Biden's still the president. No one seems to notice. But Biden should dissolve the Supreme Court.
Dissolve the Supreme Court?
I'm the president. I'm the king now, like you said, and go home.
Okay. Good to see you're centrist.
So obviously that disappointed the unfortunately too centrist Bill Maher. I should also say that the president, of course, doesn't have the constitutional authority to dissolve a coordinate branch of government. I think what she's suggesting is that Biden could take illegal extrajudicial action against the Supreme Court, perhaps arrest them. And given that they granted presidents sweeping immunity for anything within their official sphere and presumptive immunity for any official act, it would be very difficult for the Supreme Court to retaliate or defend themselves against a rogue president, which is precisely the point that no president, Biden, Trump, Republican, Democrat, it doesn't matter. No president should be afforded that level of sweeping immunity. So was it a reductive argument? Yes, of course. But it goes to a deeper truth, which is that the Supreme Court, in service of Donald Trump and aiding and abetting Donald Trump, has made it very, very asymptotically difficult to hold a rogue president accountable, such that multiple Watergate-era prosecutors who are still alive have come out and said, listen, if this ruling was in effect during the presidency of Richard Nixon would never have resigned because there would have never been any concern whatsoever that Nixon could have been prosecuted. That's how, think about that. Set Trump aside. It should be instructive enough for Trump. But I understand that it's 2024 and 40% of the country is cultishly devoted to Trump. Let's go to Richard Nixon. I think most of us agree. I think if you polled people, even most Republicans would say, yeah, Richard Nixon was corrupt. I'd argue Trump was much more corrupt, whatever. I think there's enough distance between today's Republicans and Richard Nixon that 90% of today's Republicans be like, oh, yeah, of course. Tricky Dick, Richard Nixon, of course he's corrupt. Think about it. Watergate-era prosecutors say if this ruling had been in effect, Richard Nixon would have gone on to serve the remainder of his term. Think about that, okay? to that end, there has to be changes to the United States Supreme Court. There just has to. In addition to all the corrupt practices that we have seen from the Supreme Court, particularly Clarence Thomas and to a lesser extent Justice Alito. So Ron Wyden, a Democratic senator, has actually proposed legislation within the past few days to make radical reforms to the United States Supreme Court, which go beyond even what President Biden suggested a few months ago. So I want to talk about this because it's fascinated me. The Washington Post wrote a piece on it. Sweeping bill to overhaul Supreme Court would add 6 justices. The legislation by Ron Wyden, a Democrat from Oregon, is one of the most ambitious efforts to date to remake the Supreme Court following controversies over rulings and ethics. A sweeping bill introduced by a Democratic senator Wednesday would greatly increase the size of the Supreme Court, make it harder for justices to overturn laws, require justices to undergo audits, and remove roadblocks for high court nominations. The legislation by Ron Wyden is one of the most ambitious proposals to remake a high court that has suffered a sharp decline in its public approval after a string of contentious decisions and ethics scandals in recent years. It has a little chance of passing at the moment since Republicans have generally opposed efforts to overhaul the court. Wyden, who chairs the Senate Finance Committee, said the goal of the bill is to restore public confidence in a battered institution. He said he hopes to get parts of the bill passed, even if the whole package is not embraced by lawmakers. Quote, "It's not an atomic secret that the process for selecting justices is politicized," Wyden said. Quote, "You've got this thoroughly politicized process resulting in a Supreme Court that now frequently issues sweeping rulings to overturn laws and upend precedents. We are proposing a way to restore some balance between the 3 branches of government," end quote. The bill's most significant measure would increase the number of justices from 9 to 15 over the course of 12 years. The staggered format of over 2 or 3 administrations is aimed at diminishing the chance that one political party would pack the court with its nominees. So think about that. It would expand the size of the Supreme Court, which, if you're a centrist or if you're a conservative watching, the court's size has been changed multiple times since the founding of this country. As a matter of fact, the founding fathers themselves changed the size of the Supreme Court. And not only did they change the size of the Supreme Court, they very often did it for political reasons. President Adams, once he was defeated by Thomas Jefferson in the election, shrank the size of the court so as to prevent the incoming President Jefferson from appointing or stacking the Supreme Court with his own nominees. Unfortunately for Adams, when Jefferson won, he also won a sympathetic legislature, and they were able to undo John Adams' court shrinking, and they expanded the court again. So that's just a classic example of 2 founding fathers, John Adams and Thomas Jefferson, contracting and expanding the court to benefit themselves politically. It happens. During the rollout, each president would approve justices in the first and third year of their terms. The bill would also require a ruling by 2/3 of the High Court and a circuit of Court of Appeals rather than a simple majority to overturn a law passed by Congress. Wyden said the current court has been too quick to discard precedent and curtail rights by narrow majorities. Folks, this is huge. Many other high courts who have the power of judicial review in other democracies, and indeed even in some states, need a supermajority in order to overturn the legislature's law rather than a simple majority. Which is interesting because right now in the United States Senate, we have to have a filibuster. It's not enough to have a majority. You have to have a supermajority to pass laws. Well, damn, if that's the case, then maybe there should be a supermajority requirement on the Supreme Court saying you can't just overturn a coordinate branch of government's laws. If you're going to do it, you have to have a supermajority, which unfortunately right now, conservatives could probably get anyway, given that there is a 6-3 conservative supermajority on the court. But it's a step in the right direction. The legislation would also require Supreme Court nominees to be automatically scheduled for a vote in the Senate if their nominees have lingered in committee for more than 180 days. And this would prevent the sort of skullduggery and machinations that Mitch McConnell engaged in after the death of Justice Antonin Scalia, effectively holding up the hearing of Attorney General Merrick Garland. So if McConnell tried to play that, like, hey, I'm not going to allow any sort of hearing, it would just automatically be triggered after 180 days. Let's see. Another provision in Wyden's bill would expand the number of federal judicial circuits from 13 to 15, which is why you would expand the court that way, adding more than 100 district court judges and more than 60 appellate level judges, which would reduce the workload for federal judges, which, by the way, is quite extraordinary. Supreme Court justices must report income, dividends, property sales, and gifts, among other things, but the bill would bolster financial checks, disclosures, and other transparency measures. It would require the IRS to initiate an audit of the justices' tax returns each year, release the results, and make the tax filings public. Nominees to the court would have to disclose 3 years of tax returns. That's awesome. This is good. This is transparent. If you are an unelected, philosopher king who gets to strike down executive orders from the president and, federal statutory law from Congress, I'm sorry, you don't get to be a politician. You have to be basically perfect. You should be fully transparent, even more transparent than politicians. Otherwise, you should be elected and run for re-election and have term limits the way that other politicians do. You don't get to have the ease and the comfort associated with being a politician without the burdens associated with being a politician. So pick a lane. I love this idea. Another measure would allow a 2/3 vote of the court to force fellow justices to remove from the case. So basically, that would allow a supermajority. If, let's say, a liberal justice or a conservative justice should be recused from the case, a supermajority could say, hey, Justice Thomas, or hey, Justice Sotomayor, we really think that you shouldn't be sitting on this case because there's a potential conflict of interest. So if you won't recuse yourself, 2/3 of us will vote and kick you off this particular case, right? That seems to be an effective control as well. Each justice would be required to publicly release their opinions and disclose how they voted on issues considered on an emergency basis, sometimes referred to as the shadow docket. So rather than just saying, no, we're not going to hear this case, or yes, we're going to hear this case, you have to provide your rationale as well. Folks, I think this is a solid step in the right direction. To me, this is even better than what President Biden proposed. Now, of course, what President Biden proposed that this thing lacks is a constitutional amendment which would effectively overturn Trump v. United States and make it very clear that no one, including presidents and former presidents, are above the law. But of course, you need 2/3 supermajority in both chambers of Congress, which is virtually impossible, and then 3/4 of the states to ratify. That's why we have the hardest constitution in the world to amend. Literally 12,000 attempts to amend the Constitution in 250 years, and we only have 27 amendments. Think about it. It's a fraction of a fraction of a fraction. Just ridiculously counter and anti-majoritarian to the umpteenth degree. It's why we have so much gridlock and lack of progress in this country. And yeah, I understand that the president can't snap his fingers and dissolve the Supreme Court, and that would probably be a bit too dangerous. But Ron Wyden's bill about strict ethics requirements, which would go for conservative and judicial judge or liberal judges, conservative and liberal, and also expand the size of the court. I think these things are a solid step in the right direction. Unfortunately, Republicans are going to oppose it every step of the way. And that, my friends, is why we need a Democratic president in 2024 to win. We need Vice President Harris to win the election. And we need a Democratic Senate and a Democratic House to make this happen. So vote accordingly. And in the meantime, let me know what you think in the comments.